Hello everyone and welcome. My name is Dan Sampaio and it's my pleasure to open today's Mondac webinar in association with HFW. Before I hand you over to our esteemed panel, a housekeeping item. You are able to submit questions today by using the toolbar on the right hand side of your screen. We'll endeavour to answer as many as possible, but they will all be sent on to the team who will be in touch. I'm very happy now to hand you over to Rick Brown to begin. Thank you.
Thanks, Dan. Good morning, good afternoon, or good evening, everyone, wherever you are in the world. My name is Rick Brown. I'm a partner in HFW's London office and co-head of our Global Fraud and Insolvency Group. Today's webinar is called Cross-Border Fraud Dubai to BVI via London. The plan is for kind of 45 minutes or so of chat, and then kind of 15 minutes or so of questions at the end. As Dan said, if you could put your questions in the chat function, we'll try and get to them and kind of group them together as appropriate. And thank you also for those people who've submitted them in advance. It's very helpful. So let me introduce the panel from perhaps east to west. So the furthest east from, certainly from London anyway, is Nick Braganza, or our Nick Braganza and Tanisha Saxena from our Dubai office. Nick is a partner in our Dubai office, I say. He joined HFW in January 2021. He's been based in Dubai for 10 years or so, and is a commercial litigator with a broad practice and particular expertise in dealing with claims in the DIFC and the ADGM courts. In recent years, he's been involved in some high-profile fraud and insolvency cases in the UAE. Tanisha is an associate in Nick's team and specialises in international fraud and insolvency dispute resolution, usually on complex cross-border and high-value matters. Moving a bit further west, Simon Jerram. Simon's a partner in the London office together with me in our fraud and insolvency team. He advises insolvency practitioners, creditors, directors, and other stakeholders on complex cross-border insolvency matters. And last but by no means least, over in the Caribbean, the furthest east is Scott Cruikshank, west even rather, is Scott Cruikshank. He's the office head and head of our BVI litigation team, which we launched in February this year. He's worked at the forefront of complex, high-value BVI litigation for almost 15 years and has got considerable experience in shareholder disputes, insolvency, fraud and asset tracing, trust litigation, and corporate and commercial disputes generally. Welcome to you all. This feels very familiar. Of course, we're used to, as a team, sitting down around a virtual table, but this time we've got an audience, so everyone on their best behaviours, please. I'm sure we will be. And as you all know, we kind of came up with the idea of doing this talk mainly because of the number of fraud and insolvency cases which we as a firm and as a team have seen coming out of the Middle East, and I guess to Dubai in particular, since 2018, 2019. Perhaps a smidgen before then, but certainly since then. And perhaps Nick's going to come on to discuss why Dubai seems to produce such a steady flow of these kind of cases. But I think as we head into some very difficult economic times at the end of this year and beyond, everyone's crystal ball is going to be predicting that there will be more and more of these kind of frauds coming out of Dubai and the wider region. And so probably with that, Nick, let's just jump straight into it, moving to the source of what our topic is all about. There have been some high-profile fraud cases that have come out of Dubai and the UAE in recent years. And two questions for you, I guess. Why do you think that is in particular? And secondly, how well equipped are the courts in the UAE to deal with these kind of fraud cases?
Thanks, Rick, and good afternoon, good morning, everyone. I think, yeah, you're right. There has been a whole glut of cases in the fraud space coming out of Dubai, the Middle East. It seems Dubai has that specific focus. I think there are various reasons for that. I don't think it's one particular reason. I think it's a combination and a perfect storm of the right situation, circumstances here in Dubai. I think it's relatively easy to set up companies in Dubai. You've got limited corporate governance, very strict banking secrecy laws, a hugely transient workforce. So a whole range of reasons. I think we are very much geographically at the crossroads between Asia, Africa, and Europe. We have people coming from all of those regions coming to Dubai. There's a high degree of wealthy people, wealth in this country, in this city, and plenty of opportunity to spend the money. And so I think, you know, with the big projects, some of the biggest construction projects and other projects happening here in Dubai, big ambition makes big opportunity to carry out those frauds for those who are intent on conducting themselves. Fraudulent behaviour seems to kind of go under the radar when the projects are so big. I think, you know, in terms of examples, you know, many of you will be aware of a number of examples. I thought I'd mention two main ones which we've seen in recent years. The first was Abraj Capital. Abraj was one of the largest private equity funds in the world. You know, it was a poster boy for the Dubai International Financial Centre, the DIFC, where they were focusing on sustainable projects in emerging markets across the world, Africa, Asia, etc. You know, they managed to attract some very high-profile investors, including the Bill and Melinda Gates Foundation, the International Finance Corporation, which is part of the World Bank. And this all unraveled a few years ago. I mean, what came out was that that Abraj had used its partnership stakes in its own funds to guarantee bank loans, and this kind of accelerated as cash flow worsened. Abraj dipped into funds that it held, which it didn't actually own, allegedly. And we understand that you know, there was about $1 billion in a healthcare fund. Bill and Melinda Gates, etc., started to raise some questions, and this led to a spiral. You know, it was all focused on executives, including Arif Naqvi, who was the founder of Abraj. Litigation, though, was not restricted to the UAE, and we saw huge amounts of litigation in England, in the States. You know, there was extradition proceedings, obviously in the Cayman Islands as well. So that's one big example of a case which has come out of the UAE. Another one is the NMC healthcare case. NMC is a medical company, pharmaceutical business, established in the 70s. It was one of the first companies from the UAE to actually be listed on the London Stock Exchange, and you know, it was doing great things. You know, they're running lots of hospitals and clinics all around the UAE and indeed the world. But there was some financial irregularity which was uncovered back in 2019, 2020. Red flags, you know, serious doubts of the company's financial statements. Was Muddy Waters, a New York investment firm, did an investigation. This all accelerated, and again, we've had a whole glut of litigation spiraling off the back of the NMC matter. NMC itself went into administration, and we really saw this trend of litigation happening in England, in the BVI, in the States, and we were lucky to be involved in some of that litigation. Some of you may be aware we were acting for Abu Dhabi Commercial Bank, which was one of the largest creditors of NMC. So it's been a very interesting few years. I'm sure we'll see more of it. As to your second question, do cases like this get litigated in the UAE? Well, yes, they do, but there are limitations. I mean, there's no standalone fraud offence in the UAE, and it usually, I'm talking about onshore rather than the financial centre, but onshore there is no standalone fraud offence. Often you need criminal proceedings alongside it, and you're then dependent on a private prosecutor, which, you know, as everywhere, they have their priorities and are often overworked and progressing those claims. White collar crime it can be challenging. Then you've also got what I mentioned earlier about people not being here and their assets necessarily not being here as well, and actually the need to go and get assets where they're most accessible, and protracted proceedings in the UAE courts might not get you access to those assets in as quicker time frame as you'd maybe like. There's also the lack of publicly available information on assets, on property, corporate shareholdings, etc., which makes actually knowing where the assets are particularly challenging in this jurisdiction. So I know that we had a question before we started this presentation, and it was about whether the title of our presentation today is Dubai to the BVI via London, and the question is, are there other jurisdictions in the Caribbean where frauds are litigated? And certainly so. I think especially with the Cayman Islands, as we saw with the Abraj example, that there was extensive litigation going on in the Cayman Islands, and the funds that Abraj held were in the Cayman Islands. But I think the focus of this talk will be on the British Virgin Islands. HFW is very fortunate. We have Scott, and we have an office in the BVI, and we can really showcase those capabilities across the world through this presentation.
Which takes us on nicely, Nick, to go, if we may kind of leapfrog you slightly over in London, go over to the Caribbean and ask Scott how and why fraud cases originating in Dubai and I guess the UAE get litigated in the BVI. Can you hear us, Scott?
I can hear you now. Can you hear me, Rick?
I can. Sorry, just the question.
Yes,
the question was just, Nick's kind of teed up the origination, as it were, of frauds coming out of Dubai and the UAE. Just for present purposes, we're going to hop over past London and go into the Caribbean and ask you why or how and why fraud cases coming out of Dubai and the UAE get litigated in the BVI where you are.
Yes, it's a good question. Thank you for that, and hello to everyone listening. There are a number of ways in which fraud cases might find their way to the BVI courts, and I think the reason for that is quite simple. BVI companies are very commonly used in group structures throughout the world or as joint venture vehicles. There are in the region of about 500,000 active BVI companies. It therefore follows that where a BVI company is used or involved in a fraud, that aggrieved parties can seek the aid of the BVI court in pursuing justice. So, depending on the facts of any given case, the BVI courts can principally assist in one of three ways, I would say. Firstly, it might be possible to litigate the matter substantively in the BVI. Secondly, the BVI courts can provide interim remedies in aid of foreign court or arbitration proceedings. And thirdly, the BVI courts can enforce foreign judgments in the BVI from other jurisdictions, thus giving the judgment teeth against BVI assets. And that might typically be, the assets might typically be shares in BVI companies. So it might assist just to go through each of those three topics in brief at this stage. The first one I mentioned was substantial litigation in the BVI. There will clearly be circumstances where the BVI is a more appropriate forum to litigate the claim substantively. Now that might be because the parties are all BVI companies, or that the individuals are somehow connected with the BVI and or connected with BVI companies. We've recently worked on a case in the BVI involving alleged frauds against about 60 parties, including some BVI companies and other parties who didn't have particularly strong links to the BVI or elsewhere. That case went all the way to the Privy Council. The case is called Eurocam, the case. It went all the way to the Privy Council, which is in London, which is the highest court of appeal for the BVI courts. And in that case, the Privy Council confirmed that the claim was to be run and litigated in the BVI, despite the forum challenges brought. So that might be seen as a good example of what people see as the BVI being readily prepared to claim substantive jurisdiction in matters where little else points to the BVI, other than perhaps the use of BVI companies to help facilitate fraud. On the subject of substantial litigation in the BVI, it's important to note that the BVI courts are very highly regarded. They have a very high quality judiciary, which is uncorruptible. The law is based on English common law. It has its own dedicated commercial court, and which is well accustomed to dealing with commercial disputes, including frauds. As I've already mentioned, the ultimate court of appeal is the Privy Council in London. The BVI is very accustomed to dealing with fraud cases. It routinely does so. It's produced its own substantive body of case law, again based on English common law, and pulling all this together, it gives litigants a tremendous confidence in deciding to litigate before the BVI courts. The second point I mentioned was interim remedies in aid of foreign proceedings. So there might very well be substantive proceedings afoot elsewhere, and that might, for example, be out of Dubai or elsewhere. And with that in mind, the BVI courts can assist by granting interim orders in aid of those foreign proceedings. The jurisdiction to do this was originally based at common law, but it's now embodied in statute. It's section 24A of the Eastern Caribbean Supreme Court Act. And this gives the BVI courts a full arsenal of interim remedies, which it can grant in aid of foreign proceedings. These foreign proceedings might, as I mentioned, they come out of Dubai, Middle East, or frankly anywhere else in the world where there are fraud cases ongoing. Common examples of these interim remedies include freezing injunctions on both a domestic and worldwide basis, knowledge pharmacal orders, or in other words, that's disclosure orders, CHABRA orders, proprietary injunctions, and in the more extreme of cases, the appointment of receivers over BVI companies.
Scott, can I just ask, Scott, sorry to interrupt, just for those that don't know, just explain briefly what a Norwich pharmacal order is. I mean, we're very familiar with that, but that term, but for those that don't know.
Yeah, of course. Yeah, a Norwich pharmacal order is basically an order for the disclosure of information, and it typically it will be directed against a third party who has been unwittingly mixed up in a fraud. So I was just coming on to you. One of the examples in the BVI of cases I've done recently in the BVI was a Norwich pharmacal order, and I mention this one because it arose out of the Middle East. Was a Norwich we obtained a Norwich pharmacal order against BVI registered agent in respect of suspected foul dealing with shareholdings, and this is something we're seeing increasingly in the BVI as Norwich pharmacals or orders being directed against BVI registered agents. As I've said, these are third parties who have become somehow mixed up in a fraud. Another example of work that we saw come out of the Middle East relates to freezing injunctions. We successfully obtained a domestic and worldwide freezing injunction in respect of against an alleged fraudster and 5 BVI companies which were associated with him. So this gives some flavour as to the things that the BVI courts are prepared to do to assist fraud cases generally, in aid of foreign proceedings. And the final matter I mentioned was the enforcement of judgments. I don't intend to go into this in any particular detail, but the BVI has a very well-established means of providing for the enforcement of foreign judgments. That can be done pursuant to BVI statute or common law. It's important to note that arbitration awards may also be enforced in the BVI, and indeed pursuant to arbitration legislation, it's relatively easy to enforce an arbitration award here. In respect of fraud claims, this can assist greatly where the anchor jurisdictions elsewhere. It might be in London, it might be in Dubai, and once a judgment is obtained, then the holder of that can seek to enforce against assets within the BVI, and that's often enforcing on the shares of a BVI company. There was one case which again we were relatively recently involved in. It didn't arise out of the Middle East, but it was a very interesting enforcement case. It was an American client had a long-standing judgment, arbitration award against a Taiwanese company. It struggled for years to enforce the judgment until someone discovered that the Taiwanese company had a BVI subsidiary. So matters then came to me in the BVI, and we sought to enforce against the shares of the BVI subsidiary. In doing that, we were able to, on an ex-parte basis, we were able to recognise the arbitration award, appoint receivers over the shares, and the receivers had the power to vote the shares, which they immediately did. And so by the time the Taiwanese company discovered, were given notice of events, it was the subsidiary was no longer under their control. So that matter resolved very quickly thereafter. I'm conscious of my time. I think the only other point which I think would be worth mentioning in the context of fraud and BVI is the BVI has it has its own insolvency legislation, and very often it's the case that companies are wound up for reasons of fraud. They might be wound up on a just and equitable basis as opposed to an insolvency basis because of any alleged fraud. I think that's all I've got to say just now, and I'll pass back to you, Rick.
Oh, okay, thanks, Scott. I guess going back across the Atlantic to London to you, Simon. So Scott's obviously talked about, in particular, some of the ancillary nature of the BVI court's assistance. But assuming that the proceedings are going to be centred in London, why do you think, or how and why would victims of fraud initiate proceedings in England in our jurisdiction, and what remedies are available to claimants in those courts?
So thanks, Rick, and hello everyone. Nice to speak to you today. I think the first point to bear in mind is the English courts are very well regarded globally. They have a long history. They've got an experienced judiciary, and this gives certainty and efficiency in resolving any disputes, whether they arise out of the UAE or anywhere. But why would a creditor, let's say, be looking at England as a jurisdiction? There might be, well, some examples. There might be assets here that you might want to enforce against, and I think Nick touched on this earlier. If you've got a defendant based in Dubai, for example, they may not have assets there. They may have assets elsewhere, including in England. You might want to also get hold of documents or information from individuals or entities based here. One of the prime examples of that might be banks based in London, and you might be seeking to obtain some form of disclosure from those banks. You might also have an English company at some point in the corporate structure, and that you might want to as Scott was just describing, enforce against the shares in due course. Or you may just simply have a defendant that lives here, and that's why you come to the English courts. But ultimately, to use the English courts, there needs to be some connection with England, much as Scott was describing in terms of having some sort of nexus with the BVI to commence proceedings there. But when dealing with an international fraud, there are often good reasons to try and find that connection, so as to try and commence proceedings in England, or in some way use the English court process in support of the foreign proceedings. And I thought, just in the next sort of few minutes, I thought it might be easiest to take this in 3 stages. So one, why would you think sort of the pre-litigation steps that you might be taking and why the English courts might help in those circumstances? Secondly, some key points to bear in mind when you've got litigation here and what you're bearing in mind during the course of litigation. And thirdly, then in the enforcement scenario. So taking first the sort of pre-litigation steps. And so regardless of whether you've got English or foreign substantive proceedings, so whether or not you're going to bring claims in England, your substantive claims in England or abroad, you can ask the English courts to grant some sort of injunctive relief in fraud cases, often before the litigation is commenced, to protect the assets against which you might be seeking to enforce in due course. And this applies even, as I was saying, in the case of foreign proceedings. So it might be helpful where, even if you've decided that the only place realistically you can commence the proceedings, let's say, is the BVI, you might still want to seek some sort of injunctive relief before the English courts. And we've got a case at the moment where we had litigation in the BVI, and we sought and obtained a freezing injunction before the English courts in support of those BVI proceedings. And that's sort of the opposite of what Scott was describing earlier, where you might have English litigation but go and get a BVI freezing injunction. And this can be a very useful tool to try and put a stop to any steps that the fraudsters might be taking in relation to their assets, because, as I was saying earlier, the English courts are very well regarded. And if you serve an English court order on some banks or bona fide third parties or service providers, whatever it might be, that can create a lot of difficulty for the fraudster to continue to operate. You could also seek disclosure orders pursuant to either the Norwich Pharmacal and or Bankers Trust jurisdictions, and Scott was sort of mentioning what they are earlier, in order to obtain information or documents that will either enable you to identify who the wrongdoer is and potentially where they're based, or to plead your case against them. And we're seeing this in the case of sort of crypto frauds, where a crypto exchange can be ordered to provide information as to the identity of the fraudster or what actually happened in relation to the transactions that were made. And I've got a case at the moment where we're going through various rounds of Norwich Pharmacal applications to try and piece together a picture of how the fraud actually operated. And I guess the other point to consider pre-litigation in England is funding. And litigation funding is often used in fraud cases because a party may have lost a considerable amount of money as a result of the fraud and is therefore either unable and or unwilling to commit further funds in order to pursue that fraudster. And bear in mind that fraud cases can often be very lengthy and very complex and involve asset tracing in a number of jurisdictions. So as I say, funding is a key issue, and there's a developed industry in London relating to litigation funding. And there are lots of options open to claimants who might be considering their options in that regard. And this funding can cover both the interim relief that we were describing earlier, the sort of injunctive relief, the main action, and also enforcement subsequently. And it's a way for a claimant to mitigate the downside in return for giving the funder a share in the upside. But on the other hand, one reason why parties might be wary about, I guess, using the English court jurisdiction is the adverse costs risk. If you have litigation in England, the usual rule is that the loser has to pay the other side's costs. And I'm often dealing with cases involving, say, the US, where parties say, well, actually, I'd much rather sue in the US because there is not that adverse cost risk if I lose. But there is the option, whether instead of or in addition to litigation funding, of going out and purchasing what's known as adverse cost insurance, which would cover you in the event you lose and you have to pay the other side's costs. And that could even be on a fully contingent basis. So you only pay that ATE premium, the adverse cost policy premium, in the event that you're successful. And as I say, that's a way of minimizing the potential downside. So just going on to during the course of litigation, what you might want to consider when commencing proceedings in England. First is potential challenges to the jurisdiction. So you need to ensure that your connection with England is good so as to avoid any potential challenge by the defendant to the English court's jurisdiction. And in my experience, a fraudster will seek on any possible argument to challenge the jurisdiction, even if it's not very strong, in order to try and delay the substantive resolution of the proceedings. And actually, this happens in all jurisdictions. So even if you have, say, litigation in Dubai, the defendant may challenge that jurisdiction in favor of the BVI just to delay the resolution of the proceedings. Secondly, disclosure. And as we're all aware, I mean, disclosure is critically important in a fraud case because the evidence is going to be necessary to prove your case to the requisite standard, to counter the arguments and evidence that might be put forward by the other side. Now, in England, the traditional rule was that standard disclosure is ordered, but now we have what is known as the disclosure pilot scheme, but actually that's going to be made permanent later in the year. And that's designed to sort of narrow the scope of disclosure and the process around it. And it can range, the disclosure that's ordered can range from very wide-ranging search-based disclosure to virtually no disclosure other than known adverse documents which support the adverse case, the other party's case. And sanctions obviously apply for failing to give proper disclosure, which you could seek to challenge the other side's disclosure on. Finally, just in the context of during the course of litigation, is security for costs. And you as a claimant will want to ensure that you are protecting yourself against a defendant who fails to pay your costs when ordered to do so, particularly in a fraud case where the fraudster will have hidden assets or taken every available opportunity to prevent the enforcement of the costs order. You don't want to be having to go to, say, Dubai or elsewhere in the UAE to try and enforce a costs order after you've obtained judgment in your favor. And the English courts routinely grant security for costs, particularly where defendants are based overseas or there's evidence that they can't pay the costs order if ordered to do so. And then just very quickly thinking about enforcement, and there are various mechanisms by which you can enforce an English judgment. And in my experience as well, foreign courts are generally willing to recognize and allow enforcement of English judgments in that foreign jurisdiction. But you can enforce, even if you've obtained, say, a BVI judgment, you could look to enforce that. You could look to recognize and enforce that in England to try and enforce against assets based here. And just one final point to mention is that if you've got, I mentioned an example earlier where you may be seeking to litigate in England because you've got an English company in the corporate structure. When you come to enforcement, you could seek to appoint a liquidator over that company who can then get information in relation to the fraud using his statutory powers, including in other jurisdictions through cross-border recognition. And I've got a case at the moment where we sought recognition of a liquidation in the US, and then we can use what are known as the Chapter 15 powers under the US Bankruptcy Code to seek wide-ranging disclosure from third parties based in the US. So that's just a quick run through of why you might use the English court system, provided you can find some sort of English connection, Rick.
Good stuff. Thank you. Tanisha, I guess over to you and to discuss if in a fraud case it's plainly evident that the fraudsters are in the UAE. I presume it's possible, but perhaps you can explain. It's going to be possible to bring proceedings in the DIFC or ADGM courts. Perhaps you can explain that and whether that's desirable to do so.
So thank you, Rick. Firstly, what are the DIFC and ADGM courts? These are English language common law courts within the UAE that operate separately from our civil law Arabic language courts. The DIFC court's based in Dubai. It's modeled very closely on English courts, and it offers remedies that one would be more familiar with in the UK. So freezing orders, search orders, third-party disclosure orders, and so forth. So how can the DIFC court have jurisdiction in fraud cases? Well, the DIFC would have exclusive jurisdiction if a company is incorporated in the DIFC, or if the subject matter involves contracts that were partly or wholly concluded in the DIFC, or if the fraud itself was perpetrated in the DIFC. The DIFC also has jurisdiction to make freezing orders in support of foreign proceedings in circumstances where there's no substantive cause of action in the DIFC. So that helps with, cases that are being litigated in the UK or in the BVI. I'll just pass you on to Nick quickly, who wanted to mention an interesting fraud case that was determined in the DIFC.
Thanks, Tanisha. I think what I wanted to mention was, obviously it's all very well if you're in the DIFC, but what if you're not? And then quite often you're not in the DIFC. Most of the UAE is not the DIFC or the ADGM. In a case that I was involved in a couple of years ago, there was a fraud perpetrated. It was a misappropriation of some bonds by an Abu Dhabi entity. And the bonds were held in a bank account onshore Abu Dhabi. Now, we went through a process of several months trying to target him onshore in Abu Dhabi with limited success. As I said, you get stuck with the criminal proceedings, which may take a while to progress. So we initiated proceedings in the DIFC. Now, in order to get the DIFC to assume jurisdiction over the dispute, we actually initiated proceedings over the bank. Now, the bank had the bonds, and we argued that the banks were subject to the jurisdiction of the DIFC. The bank actually wasn't incorporated or even having an entity within the DIFC. However, the bank was licensed to conduct business in the DIFC by the Dubai Financial Services Authority as a recognized person. And it worked. The DIFC assumed jurisdiction over the bank. So we had the bank. We managed to get a Norwich pharmacal. So the DIFC courts, like the English courts, BVI courts, will issue a Norwich pharmacal. Well, it's a banker's trust here because we're talking about a bank. So the bank disclosed the information about where the bonds were, who owned them, where they'd gone. And then we were able to make an application to join the fraudster to the DIFC proceedings. Under a case called Ness Investments, the DIFC courts will agree to add additional parties to a dispute if it's in the interest of justice, if they are the necessary and proper parties, and we have similar tests in the English courts and other common law courts. So we're able to bring in the fraudster into the proceedings. The bank's not interested anymore. Like we don't want to target the bank. Now we've got the fraudster who actually participated in the proceedings in the DIFC court. So that was an interesting way that it is possible in the UAE to bring in people outside the UAE, outside the DIFC into proceedings in the DIFC courts. I think Tanisha's going to talk briefly about the ADGM.
Yeah, so the ADGM is also a common law court based in Abu Dhabi this time, and it directly applies English law and also offers those interim remedies that we can avail in the UK courts and in the BVI courts. The jurisdiction of the ADGM courts is again similar to the DIFC, so the ADGM would have exclusive jurisdiction if a party is incorporated in the ADGM or if the subject matter of the dispute involves a party that entered into a contract partially or wholly in the ADGM, or again, if the fraud was perpetrated in the ADGM. The ADGM, though, has this interesting procedure whereby companies can be passported in, and effectively a company can use the ADGM company regulations and re-register to become an ADGM company and therefore effectively become subject to the jurisdiction of the ADGM. So this was actually famously done in the NMC case. NMC re-registered to become an ADGM company effectively to benefit from the ADGM insolvency regime. Now, NMC was actually a very high performing group, as Nick mentioned earlier, and it wanted the business to continue, and therefore it wanted to benefit from an administration process that was available in the ADGM. And that's what happened. The ADGM court issued an administration order, and Alvarez and Marcel were appointed as liquidators, and I guess the rest is history.
Very interesting. Well, one point I was interested about, Nick, in particular, is enforcement in the UAE, because assuming that there are assets there, I hope you can find assets against which to enforce. The question a lot of people ask is, well, how easy is it, or is it easy to enforce in the UAE? What would you say to that?
It's a long, complicated question. And probably could speak about this topic for the whole presentation. I think
You've got about 2 minutes. 3 minutes.
Yeah, I've got 2 minutes. So previously there was real challenges in enforcing foreign judgments onshore in the UAE. It was next to impossible to do so. About 8 or 9 years ago, people came up with the idea of using the DIFC as a conduit to enforce the judgment. So you enforce your judgment in the DIFC first, and the DIFC, like all good common law courts, will enforce judgments from other common law jurisdictions pretty readily, subject to certain circumstances and conditions, of course. But then you can take your DIFC judgment and then enforce it onshore. And the judicial authority law, which governs the inter-enforceability of judgments from the DIFC onshore, was very good. Anyway, that worked for a little bit, but there was some, big cases, and there was the establishment of this judicial committee to deal with conflicts of jurisdiction between the DIFC and Dubai. That led to a kind of backlash, and we didn't see the conduit working very much. The Joint Judicial Committee, which was established, determined that if you want to enforce in the onshore part of Dubai, then you should go to the onshore part of Dubai to enforce your judgment. Notwithstanding that there will be challenges, there is a legal mechanism for you to do that, so you should do that. So that, there were those challenges then, and what happened? Actually, it became easier. They changed the law. The Civil Procedure Code was amended in 2018 to facilitate the enforcement of foreign court judgments. But there was always this issue that was faced. Either the Dubai courts, the UAE courts, felt that they had jurisdiction over the dispute, so the foreign court didn't have jurisdiction, and therefore we would not enforce those judgments. Or alternatively, there was this reciprocity issue. Now, in common with many courts around the world, the UAE courts would not enforce a judgment of a court which would not enforce their judgments. So we need to have reciprocity, mutual respect between the courts. And we found that generally a lot of courts in Europe, for example, were not enforcing those judgments, and so equally the UAE courts would not enforce their judgments. However, we had a bit of a breakthrough. It was the week before last. Well, actually, the breakthrough happened about 1.5 years ago, and there was a case called Lencore in the English courts, where the English High Court agreed to enforce a UAE judgment. It was on a summary basis, and following that decision, we said, "Oh, we've got reciprocity now." But it took a while to filter through, up to last week, where they issued, the Ministry of Justice issued a letter, a notice to everyone saying, "Look, we will now. There is reciprocity following Lencore, and so that condition, in order to enforce a judgment, an English judgment that is, in UAE has been satisfied. There are other conditions to be met. We need to have a final judgment. There needs to be, jurisdiction, etc. But there is reciprocity. So if everything else is satisfied, then the UAE courts will enforce an English court judgment. However, difficulty, it's not all plain sailing. This is the UAE after all. And a particular problem that we face is interim relief. The UAE courts generally will not enforce an interim order, freezing injunction very easily from the UK courts or from the BVI courts. We have had some success in enforcing freezing injunctions issued by the DIFC courts onshore. And some of you may be familiar with the case of the ship, the yacht owned by the billionaire, which was moored in a port in Dubai for the best part of 2 years, following a freezing injunction issued by the DIFC courts, which was then recognised onshore. But yeah, no, certainly there are developments, and this place, things change all the time. But it does seem that it is going to be easier to enforce your foreign court judgments here in the UAE, at least if they're from England.
Good stuff. Well, look, we've taken 45 minutes. We've got 15 minutes or so for questions. Thank you to those. We've had some that have come through, so perhaps I can just turn to those. Not sure whether I should name and shame who's asked them. Perhaps I'll keep them anonymous. It doesn't really matter, but thank you. We know who you are. The first one is a question, I guess, probably to Nick and Scott. So the question is, the statement is, Dubai and BVI are notorious for shielding individuals and entities from scrutiny because their corporate registries provide limited information on the UBOs and the shareholders. What steps do you take to unravel the corporate structure to reveal the real puppet masters? Very well put question, Matt. So how do you get behind the ownership structure of these companies in the BVI and in Dubai? Scott, do you want to go first from the BVI perspective?
Yeah, sure. It's a good question, very good question. It's definitely the case that because of the way matters work in the BVI, it's more difficult it's difficult to find out details of ownership of companies in BVI. Some of the tricks that we use to achieve that is knowledge pharmacal applications. I think I discussed that previously. So basically, disclosure orders, in other words, against third parties who might be mixed up unwittingly in a fraud. So again, that pulls in registered agents, and it is a requirement that BVI registered agents have details of shareholders. They should also have details of UBOs. They're obliged to do that. So this is information that they will have, even though there is not a public filing in respect of that. Directors of BVI companies, the same applies. That's information that BVI registered agents will have, and indeed there is also a requirement to file registered directors at the moment, albeit it's a private filing with the Registry of Corporate Affairs. As of January next year, for the payment of an extra fee on a search, that information will be discoverable as well. So that's opening it up a little bit. If you're a shareholder or a director of a BVI company, sometimes your innocent parties can be, your innocent shareholders and innocent directors can be pulled into fraud type cases themselves. If you are a shareholder or a director, then you're obviously entitled to under the Business Companies Act to find out who the other shareholders and directors are. So these are little tools that together with investigations generally, that allow us to chip away, so to speak.
Nick, I mean, I guess similar kind of things, depending it's on onshore or offshore, similar tactics.
Yeah, I think there are similar kind of issues, similar kind of tactics that we use here. Onshore, you can apply for an attachment order. Now, an attachment order would be, you would have to have a pending claim, obviously, in the UAE onshore courts. And an attachment is kind of like a freezing injunction where you would attach specific assets against your defendant company or person. It may be possible to use that attachment to make applications to the UAE onshore courts to seek information from authorities or the land department or other government authorities who may be willing to disclose that information. But you're not going to get much, and in terms of UBOs, that will be a challenge. They're not going to look beyond who's listed on those entities. I think in terms of if you want to go that step further, I've talked about the DIFC courts, and we have another, Tanisha and I have another case which we're dealing with at the moment, where we're actually on the other side. We're acting for the bank in a banker's trust application. So joint liquidators have company is conducting their investigations into what went wrong, and they've discovered a whole bunch of fraud, of course. And they would like to find out more information. So they approached our client bank in order to get that information. As I said, that bank is now subject to the jurisdiction of the DIFC court. So agreed to submit to the jurisdiction, and they were able to get a banker's trust order to get that disclosure from the bank. The bank was able to disclose not only accounts, bank statements, KYC documentation as to how those bank accounts were opened. And so that information has been passed over to the joint liquidators who are conducting that liquidation. So that's certainly a way that you can go beyond the corporate, go behind the corporate veil. But yeah, serious challenges here, of course, as we know.
Can I just add?
Sure,
Just from an English perspective, I mean, even though the English Companies House or Land Registry is much better in terms of actually getting information, often in a fraud case, you will often get some sort of nominee holder or subject to some sort of trust, and then you end up having to nevertheless go to the offshore jurisdiction or trace through the assets. So even though you may have a better corporate registry in England, that doesn't necessarily solve the answer, and you still need to end up with similar outcomes in the UK in terms of knowledge pharmacal applications, whatever it is, either here or overseas. So it is better, but it doesn't get around the problem necessarily.
I definitely echo that, and I think sometimes, you know, it's Companies House is seen as the answer, but actually there's prolific abuse of Companies House. I mean, you only have to see the amount of directors named as Mickey Mouse or equivalent, and it doesn't give you the answer. What I do think is very helpful, pretty much always, is detailed intelligence or investigations, largely to complement or to kind of to piece together the pieces of the jigsaw as to who the beneficial owners are. It may be you don't have much to start with. You need to go for Norwich Pharmacal first in the BVI or offshore in DIFC, and once you have that information, you can start to piece it together. But I guess the conclusion, Nick, is if you start going onshore and you can't suck it into the offshore jurisdictions, it's that much harder in the UAE.
Yeah, that's right.
Good stuff. Okay, another question we've got would be, I won't name the author, but thank you for that. It says, given the implementation of UK sanctions, I knew we were going to come on to sanctions in Russia and so on, but given the implementation of UK sanctions by the British Overseas Territories and the Crown Dependencies, that's BVI, Cayman, and other jurisdictions around the world, do you see a mass migration of incorporation of asset holding companies and structures to places like the UAE, Asian international finance centers who don't feel so bound to cooperate? That's probably kind of a pronged answer, isn't it? Nick, do you see kind of a migration of businesses to the UAE as a result of sanctions? I'm guessing we're talking about because of the Russian invasion of Ukraine.
I think, you know, we have seen a lot more companies being established here this year. You know, there was a real spike after the Russian invasion. There are no sanctions against Russians or Russian entities from the UAE government. So we have seen a lot more companies here, a lot of Russians and others establishing their companies here. But that could be for other reasons as well. We've seen, you know, a liberalisation of the rules on foreign ownership over the last 6 to 12 months. We've had the ability to get longer term visas. All those kind of things have led to many more companies being established here. So I don't think it's just because of the sanctions that we've seen a growth in those companies.
What about from your perspective, Scott? Have you seen a kind of a drop in the registrations or a kind of a migration of entities away from the BVI?
I'm not convinced that enough time has passed yet to say one way or the other whether there has been a corresponding fall in company registrations in the BVI. Russia, Ukraine, CIS region generally was a big user of BVI companies, perhaps perhaps in the region of about 15%, probably second to China, Greater China. I think it remains to be seen what the impact of sanctions will be. BVI obviously follows UK sanctions in this respect.
Yeah, indeed. Okay, and there will be no panel session at this time that doesn't mention crypto. One person has asked about crypto to say, or to ask whether, I guess it's for you, Scott, whether there are more crypto type frauds coming out of the BVI. Are you seeing more crypto type disputes in the BVI and those involving fraud?
Yes, we are. We definitely are, and more exchanges are being set up in the BVI using BVI companies. It's a vehicle and a jurisdiction that works for crypto. So yes, that necessarily means that frauds are going to come along with that as well. So yes.
But I'm guessing, I'm speculating that although they may be incorporated or so on in the BVI, the management of those crypto exchanges may not actually take place in the BVI itself. It may be that they are taking place, Nick, in Dubai or the Middle East, and therefore there's be a prime example of where you're going to get a Middle Eastern fraud, but you're going to need to seek injunctive relief, possibly in the BVI, to get you going on your fraud claim.
Nice.
Okay.
Sorry, maybe I wasn't supposed to answer that, but yes, I agree with that entire.
You're very welcome to. You're very welcome to. We've got a couple of minutes. One question came in. This is quite specific to the BVI. What are the requirements for foreign lawyers to have rights of audience before the courts of the BVI? Scott, I don't know whether you know the answer off the top of your head. You've been there long enough now. You don't need to worry about it.
I think in very short terms, join a BVI law firm in the BVI and seek admission based on being a foreign lawyer, but a foreign lawyer meaning a UK qualified lawyer. You can be admitted in the BVI on the back of being an English, Scottish, or Northern Irish lawyer, but you still need a practicing certificate, and you still need to be related, therefore, to a BVI law firm to achieve that. And of course, we've got the great advantage of having BVI admitted lawyers throughout the world because of our network at HFW. So we've got BVI lawyers in the BVI, in London, and in the Far East, Hong Kong, and China, who can service clients worldwide, different time zones.
An excellent plug, may I say. I think to end this, I think we should probably end it. We've got a couple of minutes and some big picture questions, which I don't think we can probably tackle in that time. And I'm mindful of people's other commitments. So I was going to draw it to a conclusion and say it's been really interesting. Great to see you all as always. Thank you to our audience for dialing in from wherever you are, and thank you for those that have submitted questions. Apologies if we didn't get to yours. Thank you to the panel, and it's goodbye from us. Thank you very much.